Okay, let's jump right in. We're continuing our deep dive into the MPP, the Manual of Patent Examining Procedure. Today, Chapter 300, Ownership and Assignment.
That's right. And it's maybe less glamorous than discussing groundbreaking inventions, but absolutely critical. Chapter 300 is really the rule book for who legally controls the patent rights.
It's about the business side, the legal mechanics. We're focusing today on how the USPTO tracks ownership, specifically the administrative hurdles for recording documents and interests beyond just the initial inventor filing.
Exactly. It's about transparency, establishing who has the right to act. Think of the USPTO here less as an examiner of technology and more like, well, a very specialized recorder of deeds for patents.
So we'll unpack how they track that chain of title, how people can access these records, and what assignees the new owners have to do to actually prove they have the authority to, say, talk to the examiner.
And specifically, we'll touch on MPP Section 313, which deals with recording things that aren't straightforward assignments, stuff like licenses, security interests, other documents that affect control.
Ah, okay, so not just, I sell this patent to you, but other kinds of agreements.
Precisely. Things like granting a license to manufacture, or maybe using a patent as collateral for a loan like a mortgage on your house, but for intellectual property. Section 313 explains how those get recorded.
What's the point of recording those if it's not a full ownership transfer?
It's all about public notice. The idea, under 35 U.S.C. 261 and 37 CFR Part 3, is to let the world know about these other interests that might cloud the title or affect rights, so potential buyers or investors aren't surprised later.
Makes sense. Transparency. So you record a license agreement, and now everyone knows that licensee has certain rights.
Exactly. It helps protect everyone involved. But importantly, the USPTO doesn't validate the document when it's recorded.
What do you mean valid?
Well, they accept it for the record. They put it in the file, essentially. But they don't rule on whether the license is legally binding or perfectly drafted. That only comes up later if, say, ownership needs to be proven for some action before the office. Recording is just, well, recording. It serves notice. It doesn't grant approval.
Got it. It's a mailbox, not a judge's bench at that stage.
Good way to put it. And not everything can be recorded either. Section 313 points out, for instance, you generally can't record an attorney's lien against a patent.
Okay, why not?
There's case law on that. The thinking is it's not sufficiently related to the actual title or rights in the patent itself in the way a license or mortgage is. Though there's a small loophole you can petition the Office of Petitions if you think you have a really special circumstance.
Always a petition for everything, it seems.
Pretty much.
Uh-huh.
So let's maybe start with the basics of getting any document recorded, assignment or otherwise. How does the process even begin? We mentioned history.
Right, the historical records. There's a cutoff date, isn't there?
Yes, a key date, May 1st, 1957. Assignments recorded before that date. They aren't in the main USPTO digital system.
Where are they then?
You have to go to Narrow A, the National Archives and Records Administration. They hold those older physical records.
So serious historical patent research means a trip, possibly physical or digital, to Narrow.
Absolutely. And those Narrow A records are open to the public. It just keeps the USPTO's current system focused on, well, the more current stuff.
Okay, moving to today. How do you submit a document for recording now? I assume it's not just mailing the original contract.
Definitely not. It's very formalized. The main tool is Form PTO 1595. That's the recordation form cover sheet.
The cover sheet. Okay, what does that do?
It's the summary. It tells the USPTO, what the document is, who the parties are, buyer, seller, licensor, licensee, whatever, and which patent or application it affects. It's the roadmap for the filing clerk.
And I bet you can't mix and match property types on one sheet.
You absolutely cannot. Big procedural point. A patent cover sheet is strictly for patents and patent applications. You cannot list trademark applications or registrations on it.
Separate system, separate paperwork.
Totally separate. You need a different cover sheet for trademarks. Mess that up, and it just gets rejected.
And where do you send this meticulously prepared cover sheet and the actual document, like the assignment or license, assuming you're not filing it with a brand new application?
There's a specific address. Precision matters here. It goes to Mail Stop Assignment Recordation Services, P.O. Box 1450, Alexandria, Virginia.
A dedicated P.O. box just for assignments and related documents.
Yep. Helps ensure these crucial ownership documents don't get lost in the general USPTO mail shuffle.
Okay, this highlights the need for administrative perfection, but what if, despite your best efforts, you make a small mistake? A typo on that cover sheet.
Here's where the system can be, well, brutal. If that typo on the cover sheet affects the title information, Maybe misspelling a company name slightly or getting an application number digit wrong.
Yeah. What happened?
You forfeit the original recordation date.
Whoa, wait. Even if the actual document, the assignment, or license itself is perfect, a simple typo on the cover sheet costs you the date.
Yes. It sounds harsh, but it goes back to that idea of public notice. The purpose of recording is to give clear, unambiguous notice to the world as of a certain date. If the cover sheet is wrong in a way that clouds title, it hasn't provided effective notice.
So the USPTO will fix the typo in their system if you send a correction.
They will correct their internal database, yes. But the official date of recordation, that gets changed to the date they receive the corrected cover sheet, not the original date.
So let's say Company A files an assignment on June 1st, but there's a typo on the cover sheet. Company B records a conflicting interest, maybe a security interest, on June 10th with perfect paperwork. Company A submits the corrected cover sheet on June 15th.
In that scenario, Company B's interest, recorded properly on June 10th, could potentially have priority over Company A's interest, which isn't considered properly recorded until June 15th, all because of that initial typo.
Wow. That makes that cover sheet incredibly high stakes. Accuracy is paramount.
It really is. Meticulous checking is just as important as getting the legal substance of the underlying document right.
Okay, assuming you navigate that minefield and get the document recorded correctly, how public is this information? Who gets to see it?
It hinges on the application status. If the patent application has been published or it's otherwise open under the rules, maybe it issued as a patent already, then the assignment records, the licenses, the security interests, all that stuff is generally available to the public.
Digests, indexes, the whole shebang.
Pretty much. Transparency kicks in once the application itself is public.
But what about applications still under wraps, still confidential?
Access is much tighter there. You need written permission from someone involved, the inventor, the applicant, the current assignee on record, or the patent attorney or agent handling the case.
Makes sense. Protects confidentiality during prosecution. But what if I'm, say, a venture capital firm considering investing in a startup based on their pending application, or a company worried about freedom to operate? I need to know who really owns it, even if it's unpublished.
Right, and the rules anticipate that. There's a specific exception. You can get access if you make a formal showing that you are a bona fide prospective or actual purchaser, mortgagee, or licensee.
Bona fide so, a genuine potential buyer, lender, or licensee, not just a competitor fishing for information.
Exactly. You have to demonstrate a legitimate financial or transactional interest in that specific application. It balances confidentiality with the practical needs of business deals.
Okay, that makes sense. Now let's connect this to taking action. A company buys a patent or gets assigned rights. Recording is step one. How do they then prove to the USPTO they have the authority to, say, file responses or pay maintenance fees?
This is governed by 37 CFR 3.73C. And the absolute bedrock principle, reinforced by court cases, is that the transfer of ownership must be in writing. No verbal agreements count for establishing title at the USPTO.
Needs that paper trail. So how does the new owner, the assignee, show this written proof to the office? Do they attach the whole assignment every time?
They have a couple of options for efficiency. Option one, submit actual documentary evidence showing the chain of title from the original owner to them. A copy of the executed assignment filed for recording is the classic example.
Okay, send a copy. What's option two?
Option two is the shortcut. Assuming the document is already recorded, they can simply provide a statement identifying where the evidence is located in the USPTO's records by its reel and frame number.
Ah, the USPTO's internal filing system coordinates. So you're essentially saying, you already have the proof, USPTO, just look it up at this specific location.
Precisely. It's an administrative verification. Check reel X, frame Y, you'll see we own this. It avoids resubmitting the same documents repeatedly.
Very efficient. But what if ownership isn't clean? What if, say, two companies and the original inventor all co-own the patent? Partial interests.
Now it gets complicated. Logistically challenging. If you have multiple partial assignees and they need to take some action collectively, each partial assignee has to file their own separate submission under 3.73C.
Each one. So if there are 4 co-owners,
You need 4 separate 3.73C submissions. And here's the kicker. Each submission must clearly state the percentage or extent of that party's ownership interest.
why the percentage?
Because the USPTO needs to verify that the action is being taken by, quote, the entirety of the right, title, and interest holders. They need to add up the percentages and see that it reaches 100% of the ownership acting in concert.
That sounds like a potential nightmare to coordinate, especially if ownership stakes are complex. What if the assignment documents just say A, B, and C are co-owners without spelling out percentages?
If the percentages aren't specified, the submission has to take a different approach. It must state that all the identified parties, which might include inventors if they still hold some rights together, own the entire right, title, and interest. Basically, you have to confirm everyone with any piece of the pie is involved.
Ensures no single partial owner tries to act alone when they don't have the full authority.
That's the core idea.
Yeah.
Administrative certainty that 100% of the ownership is behind the action.
Okay, we've covered sales, assignments, licenses, security interest, partial ownership, but you mentioned Chapter 300 sometimes requires recording documents from completely outside the patent system. What was that again?
Yes, this is a really interesting one that shows how the USPTO acts as this central repository. It's the requirement to record notices of arbitration awards.
Arbitration, like a private dispute resolution process, that has to be filed with the USPTO.
It does, yes. If an arbitrator issues an award that concerns a patent, maybe it settles a licensing dispute, clarifies ownership, or determines infringement between parties, the patent owner or their assignee or licensee, must give written notice of that award to the USPTO director.
Mandatory reporting of private dispute outcomes. What needs to be in that notice?
It requires specific details, names and addresses of the parties involved in the arbitration, the inventor's name, the current patent owner's name, the patent number, and crucially, a complete copy of the actual arbitration award.
And the USPTO just files this away.
They enter the notice into the official record of the patent's prosecution history. Again, they're not validating the arbitrator's decision, but they're making it part of the public record associated with that patent.
Because that award could fundamentally change who controls the rights or how they can be exercised, even if it happened outside the USPTO and outside the court system.
Precisely. It underscores that the patent file wrapper aims to be a comprehensive record of legal status and control, regardless of where that status was determined.
So, pulling this all together, this whole exploration of Chapter 300, especially Section 313 on non-assignment documents, really drives home that this is about administrative process and transparency above all else.
Absolutely. The USPTO acts as the official scorekeeper for ownership and related interests. They don't typically judge the validity of the transfer or agreement upon recording. That's for courts or later examination proceedings. Their role here is to provide a clear public record.
And maintaining that clear record, getting those cover sheets right, submitting the 3.73C forms correctly, reporting arbitration awards, it's fundamental. The smooth operation, management, and even the financial leveraging of a patent portfolio really depends on this administrative backbone.
Couldn't have said it better. Without that administrative correctness, the legal owner might find themselves unable to actually enforce or manage their rights effectively before the office.
And thinking about that arbitration award requirement, it's fascinating how these administrative records become this central legal hub, demanding inputs even from external private dispute resolution. It shows how interconnected the legal and administrative aspects of patents really are.
It does. And it leads to a final thought, maybe something for you to consider. We talked about the harsh penalty for a simple typo on a cover sheet, potentially shifting priority for recording. Now think about patents being used as collateral for major loans, forming the basis of security interests worth millions, maybe billions.
Okay.
What happens if the bank's security interest recording gets bumped back in priority because of an administrative slip-up on Form PTO 1595, a misspelled name, a wrong digit? Could a later filer, maybe another creditor or even a bankruptcy trustee, suddenly gain priority over that massive loan, all thanks to a clerical error in the assignment recordation branch? It shows how these seemingly minor administrative details can have enormous real-world financial consequences.
A chilling thought. The foundation of patent value relies just as much on administrative precision as it does on the invention itself.
Something to keep in mind. Before we wrap up, just a couple of quick but important notes for our listeners.
Go ahead.
First, a special thank you to Mike Sheppard, the creative director behind this entire MPEP audio series. His vision really made this project possible.
Agreed. His work has been invaluable.
And second, the standard disclaimer. This summary was put together using AI tools and is for educational purposes only. It's not legal advice. Always consult the official MPEP text or a qualified patent practitioner for authoritative guidance.
Absolutely critical reminders. Thanks for breaking down this complex but vital piece of patent procedure. My pleasure. It's detailed, but understanding it is key.